a lawyer. So we did the work and he actually filed it himself. So, after the preliminary back and forth, initially, the case was... We sued in 2022.
Okay. Yes.
We filed suit sometime, I think.
The complaint.
Yeah, sometime, I think, in the summer of 2022.
May 17th, 2022.
Yes. And by law, there was a period by which Papa no Anka was or responded with what is known as an answer. But so Papa no one filed a response, and my case no call into default. Now, after a period of default, you can actually go for judgment. Now, a case near Fale, we filed on 3 counts. But I couldn't say a chrome or a chrome 4. The second one was or you would in terms of Onuna or behind the medal of Yenuya Ahmed Swale.
Yeah.
Now, the third one, so say Yenuya no a serial killer in terms of Woku Chinese for Bibribi Ghana. And then the fourth one is or a criminal, the blanket word criminal. And then the fifth one by implication, say Onuna behind Woody Sembiana, that means say Abiana and no a trigger man and also no will be second and say perform the physical act that led to the foreseeable events, which is Obi. So we also included a count that he is that he claims that my client or a co-conspirator in multiple serial killings. So that was basically the gravamen of our complaint. And when it went on undefended after the response time now, we began to make preparations to move for judgment. But being that I was in Ghana and we are all based in Ghana, we reached within our network and we partnered with 2 brilliant lawyers who I would like to take this opportunity to congratulate. Okay. Atawemega Esquire, he was the father figure of the team of lawyers, and a brilliant trial lawyer by the name of Andrew Dehere. These are all brilliant Ghanaian lawyers on this case. And, at that point, we recruited them as counsel of record. And, the case went, at that point, Kennedy's lawyers came in, obviously, because near Beji judgment for the full $30 million. And so he had counsel, and counsel came and also did his thing. Reopen default, they argued that they had a solid defense. And I think right around then, and I almost got judgments from Ghana, almost really see it. And I don't know, so say almost defense to a case I because New Jersey.
We need Ghana, so case no
exactly.
In terms of no almost case. Okay.
So as defense against, but the interesting thing is that defamation sits here, say can ma ko na de wa for court baby for na ko kan it's a separate case.
Yeah.
It no to mean ko agent to Ghana and fan be defending way. You still have to prove the truth of it. And this time, in this jurisdiction, the law is the same essentially because Ghana but you sound so free other countries. There are certain times that even though of presidential value, I just said, dead into me, so India, but to me, the two na senior, especially in cases, maybe you decided that type of a case. And Emrano is the same as Ghana. Procedurally, there are certain nuances, sometimes in terms of certain dates, you have to do certain things by. And also in New Jersey, Emra drafted complaints. We were fully aware that we were required to prove what we were claiming by a higher standard than in Ghana.
Yeah.
In this case, and not even that. In this case, we were required to prove our case not by the normal civil standard, but by a clear and convincing evidence standard.
Okay.
And they responded with that, and they were able to successfully reopen the default, which paved way for them to file an answer. And they filed an answer which essentially claimed that there was some sort of back and forth between him and Anas. And we took it for what it's worth, and we forged on. And we finally got our trial date sometime earlier this year, and it was postponed. And then we finally went to trial last Monday. We started trial on Monday. We put up our case. My client testified. He testified. He brought other witnesses, and after listening to both sides, the difference between what happened with Ghana and see Johannes said, trial by jury. It's and judge, or judge back one I say judge me, no one I say judge me and send a video seminar. But normal people on the streets of New Jersey, tax-paying citizens, and a twin from. So as part of the defense, I think it's only fair that a charges counts now the buy and the civil claims now the buy. His defense was also although Oka said it was some sort of just based banter between him and Uniano, he came to court and accepted truth as his defense. And so
time I court to say sa counting na mode bono no say on Anas back and forth, right? The on the claim or make it or say banter I just say we can't wait internet and share or no they not all can say obi to be more almost tomorrow.
But all you do court media that was not
and yes, I know what kind of court no G2.
Yeah, be or maintaining the position say no can or down standing by no kind.
Okay.
Basically remember just or practice no crane di no onye boni bia.
Okay.
So to support that no or the move you try your internet to who watches a watchman. But the announced by as on only defense and so the jury had the opportunity to evaluate that and factored that in the analysis, and obviously it was not the weight that they wanted the jury to accord to it. So jury never bugui. And about 20 minutes later, the jury came back with a verdict, and there were a multiplicity of very quick. And there was a multiplicity of questions that were posed to the jury. That's the way how they arrived at the decision. It's and also unanimous. People who were picked off the streets of not picked off the streets of New Jersey, but they're to from based on address, voter registration data. And to but within 20 minutes, they saw through everything and said no. So they came back, and there was not even one juror that sided with Yapapana Samuel.
All against
8-0 on every count and on every question that was posed to the jury, including damages now about no and also crown. There was a unanimous decision. I just say it was a solid decision of the jury. 20 minutes on there was no doubt in our presentation to what you kind of lay people. These are not experts in the law.
Yeah, they are just
these are lay people
who just sat and used their common sense to come to a conclusion.
No. I would not say use their common sense.
They listen to you and they listen to the other part. It makes sense though.
And then the law is the law. No judge in this world has any power to bend the law. That sort of conduct is what causes strife and war in places. Yeah. America had the judge actually before the judge ever kind jury instruction, but catch jurors and say, "Oh no, only to be a and that's how it went. But what's interesting about Nisi and or a lawyer contrary, even though people don't give him credit for that.
At least Bonidina Anas working.
But Anas, Anas. And also a very astute lawyer, and some people walk cry a car on Jim, but sometimes a team of legal team to we come to a compromise. Now, he has been adamant about clearing his name because I have a personal experience of understanding. It's one of the worst things that can happen to someone.
Yeah.
And he absolutely took the position that he wanted a trial. He's not interested in any settlement. He's not here for the money. He's here to clear his good name that he has built over time. And in his profession, at this time, and also started doing one anything. So he always maintained that he wanted a trial to the point where sometimes there was a disagreement in the legal team. Now, procedurally, America, the peace. Schedule say, and from this time to this time, staff that work out we are dedicating it to your case. It's no small matter.
I know. I've been there. It's not easy.
Before they will go to trial, there's mandatory settlement conference. I bet say at this maybe by this time we'll be say grow or they'll commit to the right census and decide say this shouldn't go on because yes. And I acquire unfortunately me and Anas disagreed with me, but I prepared a settlement memorandum that sought to settle this case for $18 million, just like the jury came back. As you know, these days we have all kind of tools that we can use to predict certain things.
Before you go ahead, this is where the contention is, and people saying 80 million, others saying a year 30 million. Now when you read,
well, we'll come to that. Let me clarify. Let me just clarify.
Yeah.
Okay, complaints the coin. Yeah, claim for $30 million, $30 million.
Yes. Okay.
Yes. And what I'm saying is that at the before the mandatory settlement conference, or before the jury is empaneled, even though my client had firmly informed me he had no intention of settling this case because he believes that he ought to go to a jury of his peers to clear his name. But maybe let's just prepare our settlement memorandum, be thorough and be reasonable.
Yeah.
And even though he protested, I prepared a settlement memorandum that sought to settle this case for $18 million US. Okay. Now you do settlement conference, papa about court. Now the lawyers say what he was willing to settle this matter for, and they said $10,000. So honestly,
it's clarification is very, very important. Normally Ghana.
Okay.
Into Mukodru Hono, Anas initially, you have a kind of simple street language, and the damages are not paid around 30 million.